All right, welcome everybody to this special emergency broadcast that we are bringing out to you guys here in the pre-lit community. I am Stephen Palmieri, as you guys know, and we have none other than the amazing Brian Ponder, Esquire. Brian, how are you doing this morning, sir?
Doing excellent, Stephen. How are
I
you
literally said
tonight?
this morning, I'm multitasking, like looking at Facebook, and I'm like, it's not morning, it's almost midnight over here, practically
Oh
speaking.
yeah, oh yeah. We
So,
passed the
Brian,
morning.
man, so we call this an emergency broadcast. We don't like to fear monger and clickbait,
Hmm.
although we do like to bait clicks because clicks are good. But in all seriousness, so there's this little thing going on. There's this CFPB thing, and CROs are getting caught up in it, and they are getting subpoenas from the CFPB. Is that correct, sir?
Right, right.
So
Everyone
so let's
should
just
know.
yeah, let's just jump right in, man. So you've had some CROs reach out. I've had some reach out to me. Luckily, I saw your posted here the other
Hmm.
day. It was just
Hmm.
coincidental where you were like, if you are a CRO and you get a subpoena, reach out to me. And I had somebody message me,
Yeah,
and I was like, Ryan Ponder? And she was like, no. I'm like, well, you need to know him. And here's a
yeah.
Facebook intro because she had received one of these things. And so, man, I'll let you take it away. And for those of you guys watching, though, I mean, obviously, it may not affect you, but it probably will affect somebody you know. So, pay attention. And we're bringing this to you guys just to get the word out. So, Brian, go ahead and take it away, sir.
Sure. So, um, through through consultations I've had with people who have been subpoenaed, I'm aware that in that CRC case, and that's the credit repair cloud case, almost 2 dozen people have been subpoenaed, and a lot of people may not know what that means. They may have received a subpoena. I know early on in that case, Stephen, a lot of CRC users was like, should I be concerned? Should I leave CRC, etc.? So everything is sort of coming to head now. And the truth is, leaving after the case has started really wouldn't make a big difference because they're looking retrospectively. They're not looking at, just what's going on today. So it really didn't make any difference to leave. I just encourage people to become, I guess, compliant. I mean, that's the best thing you can do. It doesn't really matter whether you run now that the company is under fire, literally. So back to the subpoena. Uh, if you're a CRC user, there is a possibility that you may have received or will receive a subpoena. A subpoena is a form of discovery. Discovery is a part of litigation where either party can ask for information from the other party. That's just regular discovery between parties. Outside of the parties in the case can use a subpoena to compel people who are not parties in the case. And when I say parties in the case, a party would be a plaintiff, the person suing, in this case is the CFPB, and another party would be a defendant, which would be, for example, CRC Daniel Rosen. So either of those parties, in this case, the CRC, who's the plaintiff, the government agency, is sending subpoenas to CRC users. Um, I do have, I only have information on for sure about one of those persons, but I know it includes some of the millionaires and some that are not millionaires. So it's not all millionaire uh, uh, users that are being subpoenaed. Um, any questions so far from anyone?
We've got a couple highs. We've got, let's see, Robert Sigmund saying hello. We have Gary
Hey,
Nitskin,
Robert.
another one of your fellow attorney comrades. How are
Okay.
you, Gary? Good to see you, buddy. So, all right, so there's a suit. I'm sure everybody's familiar with that to some extent. The CFPB
Hmm.
is going after Credit Repair Cloud. We don't need to go into the details, but they're not happy with Credit Repair Cloud. And so to your point, the subpoena is a way to compel information through the discovery process. So if somebody gets a subpoena, you definitely Brian, you remember the Wolf of Wall Street, buddy? You remember
Yeah,
when the Wolf received that subpoena? What did he do with that subpoena, Brian? What did he do? Do you remember what he did?
but yeah, he threw it in the trash
He threw the trash and
and
he
everything.
urinated on it. Actually,
Right.
if my memory serves. You do not want to act like that guy because he was probably like coked out on an 8 ball and
Mm-hmm.
Quaaludes. And I don't think
Mm-hmm.
our audience fits any of those descriptions. Hopefully, so when you get this subpoena, it's time sensitive and it's a big deal. Is that right, Brian?
Right. It is time sensitive. You have to respond within the time period that it says. Um, and if you don't, there could be serious penalties from the court. Uh, the if you were a party, uh, exchanging regular discovery, if you don't respond, you have to confer. You have to say, "Hey, why didn't you respond? What's going on? You need more time." Okay. Or you could ask the court to compel them to come on, please respond. With a subpoena, it's different. If you don't respond timely, you can be held in contempt of court. Um, Being held in contempt of court can include some monetary penalties and even worse. So it's something to be taken very seriously. It's more like a court order. Now, a subpoena is not signed by a judge, is not signed by the clerk. When you have lawyers in these federal cases, it's actually signed by a lawyer. So don't see it and say, oh, the court didn't sign this, I don't have to do it. No, a subpoena can be signed by a lawyer. Now, if these were pro se parties, then the clerk would have to sign a subpoena, but these are lawyers. So a signed subpoena, and also that signature can be typed in. And so I know a lot of people have Google law degrees. So I just want to, clear up, because people say, oh, it's not signed. The judge didn't sign it. Oh, the clerk didn't sign it. Oh, the lawyer typed their name in it. Nope. Um, you know, um, that is a valid, it could be a valid subpoena. And another thing, uh, you're really going to want to get some advice on your rights with respect to the subpoena. The subpoena that I saw came with a cover letter. Someone wants to know the content. Okay, I'll talk about the content. It comes with a cover letter that says, if you have any questions, just call this number. That number is to the CFPB's lawyers. Those are not your friends. So some people, and like I said, I know a lot of people in this space right now. Everyone's a guru. They know stuff. They've read something, and I think I can do it and be fine. No, trust me. I used to be a non-lawyer, and as a lawyer, I look back at myself as a non-lawyer who read a few things and thought I knew something.
Well,
Understand, you know
I mean, let's
nothing.
just kind of chime in on that real quick. I mean, so that's a good point. I mean, this is not credit repair, guys. We are not out there trying to punk some company into a deletion, right? I mean, so when you
Sure.
get a subpoena, you are now part of the legal process, so to speak. There are certain rules that dictate what happens to you if you do not properly participate, i.e., if you don't properly respond. And they can make your life utterly miserable. I mean, they can start to ask for all sorts of documents from you, things from you. I mean, there's all sorts of ways where the subpoena power, the power to make you absolutely miserable. And I mean, I hate to say it like this, but I mean, they could try to put the small guys out of business, even through subpoenas. I mean, if they make you fly to a couple cities or do all this kind of crazy stuff. I
Hmm.
mean, most people here are like basically paycheck to paycheck. So we're not here to like try to scare anybody, but we're here to say this is not like sending a credit repair letter to Midland. Dear Midland, you suck, give us a deletion. This is like the real deal. And that's why Brian wanted to come on with me. We wanted to come on yesterday, but he was so busy responding to these. And then he called me today. He's like, hey, is it too late? I'm like, no, let's do it, man, because we got to get the information out. So, all right, so let's kind of hone in on a little bit here. So somebody gets this subpoena. Um, look, our average listener here is kind of a one-man show. I mean, we probably don't even have $5,000 cash
Hmm.
backup, let alone 10, 15, or 20, right? And so the first thing people
Right.
are thinking is, oh my goodness gracious. I mean, I just got brought into this thing. I'm not one of the millionaires. I'm the lower end of the bell curve, man. I'm just trying to get my next deal at 99 bucks a month or whatever you charge. Brian, you seem amazing, but you're an attorney. You don't work for free. So, but I need representation as you're advising me. So let's kind of talk about what does this thing look like for our actual possible people that need to come see you? I mean, do they have to drop 10, 15, 20 grand retainer? I mean, how do we help the average CRC user that gets a subpoena that doesn't have a bunch of money sitting around?
Yeah. So luckily, I will set aside an hour, do a consultation for an hour, which is only a few $100, and walk you through how you can deal with this subpoena. And what I mean by that is you have a lot of rights and options when it comes to this. First of all, someone was asking about the content. They're asking this particular subpoena that I've reviewed. They asked for information going back to January 21st, 2011.
2011. So imagine that, guys. So,
Okay.
um, so here's what they're doing. They're sending you a letter saying we've got subpoena power, and you've got no power. Your ass needs to comply, and we want things going back 11 years, not even 10
Mm-hmm.
years. I had to do the math. I'm
Mm-hmm.
like, wait a minute, is it actually more than 10 years? And
Mm-hmm.
so, if you do not have a competent attorney, I mean, if you go it alone, I mean, they can make. Can they put you like in contempt of court or something? I mean,
Yes.
I mean,
Yes. So here's the thing. First of all, isn't that ridiculous? 2011. I mean, do you know right offhand the retention requirement under TSR and the CROA? How many years?
man, I didn't even have a beard back in 2011. I was still, I hadn't even hit puberty back then, man. And you had hair in your head back then, didn't you, man?
Oh man, I had an afro in 2011.
Me.
Man, I didn't. Now that you think about it, I haven't had hair in most of the I mean, I've been bald all the 2000s. From like 2000, I think in 2000, I think 2001 was an official shave. 2000 was a real low cut, and then 2001 it was like off.
So,
But anyway,
so these subpoenas, and they're like, great news. We got the big stick, and you got the short stick, and we just bent you over the barrel.
Yeah.
And we're wanting all these things from you going back 11 years. And let's just talk about that. I haven't seen any of these subpoenas. I've got nothing in this. I think we lost Brian, actually. Hopefully he'll come back there. But what they can ask for is, I mean, they can ask for all sorts of different things from you. So here he comes back here. They can, Brian, we thought like
ran
the
me away.
UFOs came and like abducted you. I was like, where did my co-host here go?
Hit the wrong button. So,
right.
so here's the thing.
Kind of saying what they can ask for. They can ask for anything and everything. They can ask for you to extract data out of your. I mean, they can ask for emails. They can ask for you to extract if they wanted to. And
right.
That's where you have to have a guy like a competent attorney like Brian. They can say, give me all the data out of your CRM, and you got to figure out how to either object to it or freaking extract that. I mean, so the subpoena power is really powerful. And so, I mean, this is definitely no game. But so, all right, so Brian, getting back to it, when you had a little bit more hair, but now you've got no hair because you worry about these things. Right. But you found a way to help our guys where they don't have to drop a whole bunch of coin on you. So
my goal is to talk you through, if you're affected, obviously, if you get a subpoena, I want to talk you through how to get represented, how not to have to spend a lot of money. This can really be devastating if you don't respond and get situated properly. So I'm going to walk people through that process. They're asking for over 11 years of information, and to the average person is daunting. So if you've been in business that long, can you imagine having to reach back that far? I asked a question earlier. What are the retention requirements under CROA and TSR? Does anyone know?
Oh, you know what?
I think comment. Let's see. What are the comments
down here?
Here's the comments.
See that Robert Sigmund, is he the class genius? TSR 2 years, CROA 2 years for disclosures, 5-year statute of limitations.
Okay, that is correct. So it's 2 years. It's 2 years.
Robert Sigmund the brownie points right there, man. He's got
excellent job. Excellent job. So the retention requirements is only 2 years for TSR and 2 years for CROA. Another question under CROA, what do you have to retain exactly?
Your file, basically, right? Your client file.
No. And this is a good exercise.
The client contract.
Believe it or not, no.
Oh my gosh, I'm striking out over here. You can't embarrass me in my own group over here. My goodness, Brian Ponder.
It's you're gonna be surprised. Let me see. I hope I'm not misguiding you here. But anybody want to try? To
This is
sign
Robert Sigmund
contract.
says the signed statement.
Let me actually let me just pull it up for you. 15.
Let's see. Jeff Bow is saying I think he means contract. He's left the R out, but that's okay. Let's see here.
All right, so I'm gonna tell y'all where to go.
Gary Niskin, he feels your pain. That's good, Gary.
Yeah.
Yep.
Let me
We got
see.
we guess like charades now. People are just like, or what is this? This is like what's that show? The one with Family Feud. You just kind of guess. Guys need to stop guessing. Okay, it's the rights notice.
Oh, who said that?
That's Robert Sigmund again.
Oh, he's overachiever.
He is an overachiever, man.
Robert is correct. And I can tell you, let me see if I can tell you. But that is correct. You would think it would be, let me
all right, we can see Brother Ponder is pondering something.
I was actually trying to find you a statue, but yeah, it's the credit rights signing off on that notice. And on the TSR side, what do you have to retain for 2 years? It's something different for the TSR. On the TSR,
you got to keep your phone bill to demonstrate that you were never on the phone, right? Is that what you have to keep for TSR?
Close.
Oh, but that was a trick statement. If you were never on the phone, how could you have a phone bill, huh, Ryan?
Right. So in the TSR, side, you have to keep for 24 months. It's a list. It's a list of 5 things. 1, all your advertising brochures, telemarketing scripts, and promotional materials. 2, which really doesn't apply, the name and address of each prize recipient. So that's not, prize. Name and address of the customers and the amount they paid for the goods and services. And the name of any fictitious name used, all authorizations or records or express agreement required to be provided under this rule. And that's it. So in short, on the TSR side, basically all the brochures, name, address, and how much they paid. Okay. So that's correct. I think someone's saying that there. Now, trying to see, did it say? So the record requirements are different for TSR. They ask for way more than that. Okay. We have a question here to go to mainly go. Okay, so here's the thing. They're subpoenaing, sending subpoenas to get information to find a CRO who is non-compliant with the TSR and CROA to make their case against CRC. Their case against CRC is saying CRC provided substantial assistance to CROs who were violating the TSR and CROA. So if you send what they're asking, that's going to prove that you as a CRO violated TSR, violated CROA, which is going to build up their case against CRC.
Now let's talk about this. This is a good point. So, I mean, obviously we're kind of talking hypothetical in the abstract, I think, as you attorneys like to call it. But so people are coming to you, they get these subpoenas, and they're like, Brian, I love my telephone. Okay, but I'll do whatever we need to do. They're going to subpoena me, which is under oath, basically, I mean, do you, and I know you're early on in this whole thing, obviously, but I mean, like, is there a way of saying, okay, Mr. CRO, let's see if we can work out an immunity kind of a deal? I mean, because when you're subpoenaed, you're not a party to the case. So I mean, there's really like nothing for you to negotiate, or can you? I mean, how does that work out? How can you try to find some protection for your guy, even though, let's just be clear, you can't lie under oath, so the truth is what the truth is. But I mean, how can you try to find some protection for your guy before they go out there and get squeezed under the oath?
Well, first of all, these subpoenas are overbroad. It's going to be unduly burdensome to anyone that gets it. No one is able to go back that far necessarily. And if you can, the information they ask for, the things I just named to you all are the retention requirements. What they ask for goes way beyond that. However, without you being properly represented to what's called quash that subpoena or narrow it under the law, which is Federal Rule of Civil Procedure 45. If anyone wants to look up the law or rules with respect to subpoenas, it's Federal Rule of Federal Procedure, Civil Procedure 45. That subpoena can be quashed or it can be modified and limited and narrowed down. Also, subpoenas, you're only bound to give what you have. So just because something is asked for, if you don't have it, then that's fine. Now, it's a problem, obviously, if it's part of the retention items that you have to have, because guess what? If you don't have something that you should have, then that's a violation, right? With the retention requirements. So it is very, very tricky.
They're asking for production of documents.
Correct. Documents.
But
yeah, no deposition.
It can escalate or progress to a deposition, could it not?
Yeah, a non-party can be subpoenaed to appear to be deposed. So that is correct.
That's where things could become highly problematic, right? Mr. CRO, do you own a telephone? Yes. Do you like your telephone? Yes. Do you use your telephone? Yes. Do you do credit repair? Yes. I mean, I mean, obviously we're not there yet. I'm going to assume. I mean, I don't know anything except what you've posted on social media, but you know how far you are in this. But it seems like this is a brand new. Like these things just started flying a day or two ago. These subpoenas. Is that a fair statement?
Well, I think for the past few weeks they may have gone out. So people should have subpoenas now that are going to get them. Doesn't mean it's not a limit. So just because 21 have come out so far doesn't mean more won't. So if you're a CRC user or been a user for the past few years, this is something you just want to pay attention to. It's never too late to become compliant, but like someone said, the statute of limitations goes back years, so it's not something that you can just change direction and be okay. As far as negotiating immunity, I'm not aware of that kind of negotiation going on. I don't know. And immunity is usually like a criminal thing. It's but in this civil prosecution, I have not seen that type of situation happen, because consider this: they don't have to negotiate with you because they have the subpoena power. It's not something that they have to try to bargain to get what they're trying to get. They do have the power to get that information, but you have the legal power to narrow it or to even stop it because it's unduly burdensome. But as a layperson, you would not be able to accomplish that. And even if you were to call, you're not able to negotiate with the CFPB on getting this information. So, and by the way, if you are a credit repair person, that doesn't mean you're subject to the TSR. There are ways. We're gonna have to have another conversation. There are ways, even though you're a credit repair person, where you're not triggering TSR. Even if you use the phone, it's a trigger. And I think I've talked about it early on when this stuff started buzzing, but we'll revisit this conversation on how you can be a credit repair organization and not trigger TSR and still use your phone.
So I love my telephone, Brian.
You can keep it. You can still use it. I promise you.
I love my telephone. So, all right. So at this point, it sounds like the subpoenas, for the most part, well, I guess we can't even say that, but okay, if they're asking for document production, it's overly broad. And so you're going in and you're kind of beating it back, so to speak. And then I guess the end result would be then your client would have to produce a much more narrowly tailored set of documents for the CFPB. Is that kind of basically
correct? And if you after this look at the retention requirements, they're very narrow. So if you produce that and everything else, you're not really 100% compliant, you can't tell just from the retention requirements. So go and review the retention requirements. You can't tell that you violated CROR or TSR just from the retention, the documents you're supposed to retain. But what they're asking for is going to be so broad. It's if you're doing something wrong, it's going to come out. So, my goal you want to get represented. You don't want to have to spend an arm and a leg. I'm trying to negotiate to get people represented where they don't have to come out of pocket
What
is
does
my
that look
goal.
like, by the way? How does that work?
Well, trying to negotiate some mutual benefit to where I want CROs, uh, CRC needs to take care of these CROs, in my opinion. So I'm negotiating. I have successfully negotiated where these CROs can get represented and not have to come out of pocket. Otherwise, honestly, with the things they're asking for and the back and forth, it could be tens of thousands of dollars
Yeah.
in legal fees just to narrow down this subpoena request. Not only that, the stuff they ask for, and again, most people, it's like speeding. Most people are not doing 55. Okay, let's be honest. And going 56 in this case here is going to be a big problem. So we'll talk again, Stephen, but I just want to get that message out there. By the way, you can contact me, brianponder.com, to schedule a call with me. We'll go over, if you got a subpoena, we'll go over it and go over your options, take your time, and try to get you lawyered up for that case out there in California.
Well, that sounds amazing. Well, I know I said I had a hard cutoff right here on the hour. I did push my next meeting back a few minutes, so we can take a few more questions, but kind of get this. Oh my gosh,
Big
Brian,
question.
this is one we have to like crawl up on top.
Yeah, right. Got to look
Here. Let's
above
see,
the
what do we
question.
have here? Gary Nitskin. All right. Have you guys
All
considered
right, Gary.
that the CFPB is going to start issuing subpoenas to the CRC clients, not just the users? Wow, Gary, that's something. The CFPB can build their case by taking those depositions and building their case from the ground up against CRC. For example, consumer testifies that the CRC user sold their services over the phone. CFPB can then nail the CRC user and CRC itself.
Gary, look, I have another case where before they even started the case, they already had consumers' affidavits. So absolutely right, Gary. They may have done this already. I mean, honestly, with the consumer side, this has likely already been done. But you're correct. They can reach out to the consumers, and like I said, I'm doing another case where they pretty much already did that before the case began.
Well, let's talk about that real quick. So, like, if a prosecutor is worth, what do you call it, like their weight in gold,
right?
They're never going to ask anything that they don't know the answer to. Okay, and this goes back full circle to how you open this thing up, where this is not credit repair. You guys need to have consultation. So if it gets to where somebody receives a subpoena and then they end up having to go into a deposition, and they're asking you questions about your telephone and your practices and all that kind of stuff, they may very well. I mean, I had not even thought about this, but if they already have like subpoenas and depositions from your clients, and then you're like, no, well, I mean, I know I've got a phone, but the battery doesn't really work. And
this is one case I'm working on that just got started. Is
that related to this, or just
this is another case? So this part here, to Gary's question, this section here these are exhibits from information they got from consumers and advertising. So this is before the case got started. So
that's a really good point, Gary, right there. So I mean, again, just to drive home to you guys, if you or somebody gets one of these, you need to have a good representation, because I mean, if it gets to where you've got to go through depositions, these guys are they're looking to nail somebody, and they're not going to ask questions they don't know the answer to, most probably. Let's see here. We got Brian, Gary again, Gary Niskin.
Let's talk soon, Gary. Yeah. And here's the thing. Honestly, I was talking to someone the other day. The credit repair space, the CRC case, I still see their advertising. It's like, hey, start a credit repair business. It's easy. It's turnkey. And it's very attractive because you can start. You don't have to, I don't know. You literally don't have to have a computer. I mean, you could just have a phone and write a letter. It's easy entry into this space, but highly regulated. Most highly regulated areas, you have to have a license, sell insurance, sell real estate, sell securities. This is an industry you can just walk into, make millions of dollars without licensing. And it's like it's self-governing to the sense to where you have all these rules, but you follow them. You don't have to have a license, take a test, or to be sure that you know the rules. That's why you take a test, to make sure you know the rules. So
right,
99% of CROs, if I were to test you, like I gave a little pop quiz today, it's come on in, make millions of dollars, but you likely in violation. I have not talked to any CRO person that's in perfect compliance with CROA, TSR, etc. I have not talked to one. I'm not, Stephen. I haven't talked to you about what you're doing. So we're talking. I'm not saying you're not compliant. I'm just saying there
could be that one perfect person.
Yeah,
but let
me qualify that. I've never talked to any CRO and gone through their processes, and they've been fully compliant. But I haven't talked to Stephen or anything. So I'm not saying.
Well, in my training course, I give everybody a free telephone. So I mean, it's a joke there. That's a joke, by the way. So anyway.
Is it Obama phone or?
Yeah. Switching from a Motorola to a Promco phone, man. This is what you need, TSR.
Yeah.
All right. So, all right, guys.
So I want us to have more conversations about compliance. Like I say, this is a beautiful. I mean, it's amazing, but it's sort of scary, right? You have this highly regulated area. Come on in. We're not going to test your knowledge or law. We're going to test you on the law. We have all these big laws. These are huge laws. CROA, TSR, and the FTC Act. So if you violate CROA, or you violate, let me ask you a question. If you violate CROA, is that automatically a violation of the FTC Act?
Well, I think it is. Is it not?
What do y'all think? Everybody else.
I guess what I'll say is I don't have the exact answer, but CROA is basically it's an anti-deception law, which FTC Act basically kind of covers that. But that's a good question, Brian.
Next question. What about
calling me out here on my platform?
What about the TSR? If you violate the TSR,
this is like the mainstream media. When you skew away from the accepted talking points that you're advertising, what you do, it's like you're not going to be invited on for any more shows, on our news broadcast anymore.
Well, we pop quizzing them. So who said yes? Is that Robert again?
Let's see. It's Robert. Let's see. Robert. Let's see here. A violation of. Yeah, that's Robert, of course.
Robert's smart. So correct. So if you violate CROA, it's like a double whammy. You automatically violate the FTC Act. That's why they always add the FTC Act. So if you violate CROA, the TSR, you're always it's statutorily you're violating the FTC Act. So
yeah, your ass.
That's how they have it,
basically.
Yeah. That's how they have it written. So that's why they're suing under FTC. So if they can ding you on that, on something, then they can just automatically, because the consumer laws, it's attached to FTC Act. So if you violate this consumer law, then you've also violated the FTC Act because it's written very similarly. So anyway, and like I said, the reason why I want to hop on is because no one, once you go through everything, no one is fully compliant. So you don't want to incriminate yourself and set yourself up for a horrible rude awakening. You want to get properly represented so we can narrow, possibly quash those subpoenas to minimize your exposure. And it's never too late to start getting compliant. We're going to have more conversations because since there's no testing or licensing, we have to get our self-license.
Brian, Brian, I appreciate what you're saying. I know you've got your heart's in the right place, but I have to respectfully disagree. We never know that we're out of compliance until there's a judgment that states as such. So, you can't be sitting here saying all these things until we've all had our day in court and the judges ruled, right?
Well, no, you can know. Yeah, you can be. Just because you can get pulled over doesn't mean you weren't speeding. Right. So you want to set that cruise control right below so you're not speeding.
Mr. CRO, I mean, you clearly have this boiler room with like 100 telephones in it and people calling. Yeah, but
Right.
I mean, that doesn't really mean anything. I've never been tried.
Oh, right. So yeah, you don't want to be
Oh
that
my
guy.
goodness gracious. So I know we like to have fun, bring you guys good content, but really, as we kind of wrap this one up, Brian wanted to come on and we both wanted to come on with you guys. And Brian, we should not be such strangers. I feel like it's been at least a year probably since we've done a Facebook
Yeah, I
Live.
think I was in Vegas last time we did a live. I want to come on more often. I mean, look, this is one case, and that's at least 500 pages, and it just started. It just started last what? Yeah, actually no, it started in March, but I just got
Yeah.
retained on it. But it keeps me very busy. But I do want to come on and encourage people to learn, because once you get set up right, you're good to go. But a lot of people, one by one, need to update their processes, their contracts, their advertising to become compliant, because the department, and I have one case, this case is Department of Justice took this case on. So this case is from the United States of America, so yeah. Was
Us
this
folks
helpful to
down south,
everyone?
it's the
Hmm?
United States of America. That's how we say it down south, man.
America.
America. That's right.
And they call them the
So
government. In some cases, you call the plaintiff the plaintiff. And when I'm talking to the Department of Justice on this case, they say, well, the government, so
that's
I
right.
changed all my papers to put, instead of the plaintiff, you have to say the government.
That's right.
It's
That's right.
different.
Yeah, that's it, man. Well, Brian, I appreciate. We need to wrap this one up, but for those of you guys who have somebody, either yourself or have
Yeah.
somebody that you need to refer over to Brian. Brian, once again, how can they get hold of you?
Well, they can go to brianponder.com, and then there's a link on there where they'll be able to click and to set up a call. And so we'll set aside an hour to go over the subpoenas and your options, and that should be sufficient. So brianponder.com, brianponder.com.
Excellent. So that being said, we'll wrap this up for you guys. And as usual, we appreciate you guys all being super fans of the pre-lit movement. Brian, it's always a
Absolutely.
pleasure. And let us know if you've got any more public service announcements. We'll definitely
Sure.
share our platform to help out fellow CROs. And you
Sure
guys,
will.
be good. We'll talk later.
See you later.